So, dear students, welcome in this other lecture hall. Also, welcome to the online participants, and happy to proceed with the lecture series Strengthening EU Environmental Law, in which we try to provide legal perspectives for a greener Europe. And today we have again a lecturer on site. Please welcome our new colleague to the Faculty of Law, Dr. Suvi Tuuli Puharinen. Thank you. Suvi is an assistant professor of European environmental law. And only, let me say, a few months ago, you defended your PhD on normative environmental quality in EU environmental law. That's a shorter title than the real title, but this is the book that she has defended at the University of Eastern Finland in Joensuu, Finland. I truly think that Suvi is one of the new bright stars in European environmental scholarship. So I am very happy that she will today introduce you to marine protection from an international, particularly EU law perspective. So Suvi, you have the floor.
Thank you so much, Marianne, for the very kind introduction. I'm super happy to be here. Unfortunately, I haven't been able to attend the previous lectures in person. I have watched them though, but also against that background, I'm super happy to be here today. As Marianne already introduced, I'm going to be talking today about marine environmental protection law, especially EU's regulatory responses in this area. I might say already now in the beginning that marine environmental law is not necessarily the field of environmental law that has been in the forefront of environmental legal research. And also for myself, I originally come from water law area, which might sound to you that it's very similar, but actually that deals more about fresh waters and inland waters. So for me, marine environment is something that I drifted towards just a couple of years ago, but happy to be here today to present my research on the theme a bit. Just to get it started, a little bit of structure of what I'm going to address today. So I want to lay the foundations for my presentation by first taking a look at the marine environment and the different threats, its importance to us humans, just so that we know what we're talking about when we talk about marine environmental protection. Then Marianne already mentioned in her introduction that in this field of law, as in most fields of environmental law, we are dealing with international law frameworks as well as EU law frameworks. But you will see how in this field of law, the international law framework is especially important in also determining what the EU can do in terms of regulating this area and whatnot. After that, I will go a bit deeper into the substance of EU legislation, discussing particularly the Marine Strategy Framework Directive, that is the key legal instrument in this field for the EU, paying particular attention to some of the core challenges that we have faced in the implementation of this directive. And as a final step, I will discuss a little bit about the next steps in this field of law. But just to start with, in a very kind of like basic background. So why are we interested in marine environmental protection? Why is it important to have distinct legal regimes addressing marine environmental protection? Well, first of all, the oceans, they host the largest ecosystems on this planet. And as such, they are importantly a home to a lot of our remaining biodiversity on this earth. However, what is a specific feature of marine environment is that a lot of the ecosystems, the species that are there, the habitats that are there are still largely unknown. So we have known a lot about terrestrial nature for already decades, although also there the work is ongoing. But for the marine environment, it has been estimated that it might be up to 90% of biodiversity that has yet to be uncovered, that we still don't know about. And this obviously also affects our legislative situation when we don't know what is there to protect, how does the ecosystems behave and function. Well, secondly, in the face of the climate challenge that we are facing today, the oceans and the seas are extremely important in terms of reducing the impacts of climate change, also for climate mitigation, but also adaptation. And yeah, on this aspect, the need to ensure that we keep the ecosystems in a healthy and functioning state is crucial to ensure that they continue to provide us with these climate benefits. Last of all, the seas and the marine environments are extremely important from socio-economic aspects as well. So a big or like nominal proportion of our GDPs in Europe have some linkage to the marine environment. And we also have a lot of important societal objectives that are served by different activities at the sea. So we're talking about food security from fishing and from other food production aspects, but also transports, energy, cables, databases, etc. So against this background, the marine environment is also intensively used. So it's not only about the environmental values that are crucial for us, but seas are subject to multiple different human uses. Okay, so what is then the state of the European marine environment? Well, to put it very shortly, not great. As is the case for environment also in terrestrial context. So we have estimates from the European Environmental Agency saying that Europe's seas are increasingly under threat. So first of all, we have the climate change impacts. So not only are the seas important in terms of mitigating and adapting to climate change, but climate change impacts are well felt in the seas, and it actually poses a major threat to the marine ecosystems. However, then we have multiple different human activities, types of sectors that are currently operated in an unsustainable fashion, causing a lot of pressure on the marine environments. And these pressures vary a bit between region to region in Europe. Big pressure is that of fishing. So we have unsustainable levels of fishing, but also some of the practices that we use in the fishing sector are quite damaging to the marine biodiversity. Most drastic of them being the bottom trawling that basically destroys the seafloor bottom completely when this fishing method is used. Especially in the Baltic Sea region, nutrient pollution and induced eutrophication are a major problem. So in this phenomena, there is an excess loading of nutrients, so nitrogen and phosphorus go into the sea, and this triggers a process of eutrophication, which eventually leads to even very widespread dead zones. And here the situation in Baltic Sea is already quite drastic, with 97% of the sea area being problematic from the point of view of eutrophication. Same we could say about chemical and plastics pollution, which also poses a major threat. So EU-wide, up to 80% of the marine areas are threatened by these pressures. But then also importantly, physical disruptions. So different activities, different installations that we have in the seas. So energy installation, shipping, mining activities, well, also the fishing activities that I was already talked about, they basically adversely affect the seafloor bottom or even completely destroy that. And the estimate has been that here as well, it is around 80% of the Europe sea area that are degraded or even lost because of these types of pressures. And then last of all, we also have a spread of invasive species, especially from shipping. So against this background, you see that the pressures are very manifold in the context of marine environment. Some of them are happening at the sea. So we have activities that are there directly in the sea space and cause environmental impacts there. But then also we have up to 80% of the pressures from nutrient and chemical pollution that actually end up from the seas from land. So first through inland waters, so rivers, lakes, coastal waters, but then in the end they accumulate in the sea space and cause the pressure there. So against this background, we need to have legal frameworks that are capable of addressing both land-based sources as well as activities that happen to sea, and that have a degree of flexibility to address the pressures that are the most pressing in the context that they are applied. Well, recently we are in an event that is linked to also the EU Green Deal network. So I want to raise a little bit important policy objectives, policy developments of the latest years. So as probably all of you know, we've had the European Green Deal starting from 2019. And this policy framework also entails important objectives for the marine environment. Here, the ones that I want to note specifically are the biodiversity and zero pollution objectives. So as you probably well know, the Green Deal sets a quite ambitious objective of halting biodiversity loss and ensuring that at least 30% of the area is under protection by 2030. And this also applies to marine areas. So important biodiversity conservation objectives coming from there. Then we also have the zero pollution objectives, where the goal is that by 2050, the levels of environmental pollution would be no longer harmful to human health or ecosystems. And against the background that I just told you about the nutrient pollution and chemical pollution, this of course is a very crucial but also quite ambitious objective for the marine environment to tackle those sources of pollution. However, I want to already stress now in the beginning that the Green Deal is not only a positive development for the marine areas, because there is an increased emphasis on, well, climate policy on the one hand, but also interlinkedly to renewable energy policy. So upscaling the deployment of renewable energy in the energy supply in the Europe. And what this means in practice is that there's increased push to promote deployment of renewable energies also in the ocean space. So actually the biggest growth aspirations in renewable energy are targeting offshore wind. And you can see that there is actually quite exponential, the growth that is envisioned in the Repower EU strategy. So from the around 12 gigawatts in 2020, we should get to 300 by 2050. So you can imagine that this is a push for increased use of the sea space and increased pressure from energy infrastructure and installations to the marine environments that are already adversely affected by such activities. All right, so after this, I want to say a couple of words about the legal framework. So as I said, I want to showcase also the international legal framework, although in the later stages of the presentation, I will focus more on EU law. So historically, against the background that all marine regions are bordered by several states and also affected by activities of other states, marine environment has been predominantly regulated under international law. So EU did not have comprehensive legislation on the marine environment until 2008. So before that, it was mostly international law. What is a distinctive feature of the international legal framework here is that we basically have two layers of international law. So on the one hand, we have quite strong global conventions, especially the United Nations Convention of the Law of the Sea. And what is specific here is that UNCLOS actually determines the jurisdictional and administrative and legislative rights of the coastal states in the marine areas. And it does so by utilizing this maritime zoning system that I will show in a bit. So because of this, the coastal member states or coastal states, they cannot regulate all aspects of the sea area at the outset, but they have to see what kind of competencies they have in different zones of the marine environment deriving from the UNCLOS. UNCLOS is also very strong international legal instrument in terms of regulating, for instance, shipping and certain other uses in the marine areas. And actually, because of this, there's limited competence on EU, for example, on shipping at all. So in this respect, the international law framework has a very deciding function in terms of the EU's regulatory capacities to address different pressures. On the other hand, we have a long tradition of drafting regional seas agreements for specific marine areas. So in the EU, we have the Baltic Sea, we have the Black Sea, Mediterranean, and Northeast Atlantic. And for all of these sea areas, the coastal states have adopted regional conventions, especially from the environmental protection aspects of these seas. I have listed here 2 conventions as an example. So the Helsinki Convention from the Baltic Sea, and then the OSPAR Convention from the Northeast Atlantic. And the EU has gradually become a party to both the global conventions, such as UNCLOS, but also to the regional seas agreements. And you maybe remember from previous lectures that this basically means that these are mixed agreements, so international agreements that are binding to both EU and its member states. So on the other hand, they require the EU to adopt legislation to implement them, but also member states, when they are acting within the obligations of EU law, they have to adhere to the obligations coming from these international legal frameworks. So against this background, the EU's marine environmental legislation needs to adhere to these 2 layers of international legislation that affects a lot of its content, but also the scope and competencies within that. I promised to show you the UNCLOS zones, but I will reassure you I will not go through all of them with you. So basically in the UNCLOS zoning system, we have different zones that concern the seafloor bottom, and then different zones that concern the water column. But what is important in our presentation today is that the competence, the legislative, administrative, judicial competence of the coastal states, it's the biggest closer to the shore, and then it diminishes going towards the outer regions of the sea. Here, the high seas they are areas where the coastal states and hence also the EU does not have competence at all anymore. So high seas is exclusively regulated under international law. Strongest competence is on the internal waters. So in the internal waters, we usually have all of EU environmental legislation applying. So we have the Habitats Directive, Water Framework Directive, Industrial Emissions Directive, etc., fully in force in the internal waters. But then here, the territorial sea and exclusive economic zone, the member states generally do have competencies, but only within the aspects that are regulated under UNCLOS. So, for example, on marine environmental protection, there is competence for member states in these areas, and hence also EU marine environmental legislation usually encompasses the internal waters as well as the territorial waters and exclusive economic zones. However, there are some limitations on, for example, competencies regarding fisheries or competencies regarding utilization of other living resources in the territorial sea and exclusive economic zone, which might affect the competence of member states to implement environmental protection measures in these areas. I also wanted to show as a context. So here on the other hand, you have a map of Europe's marine areas. I have already talked about the Baltic Sea, Black Sea, Mediterranean Sea, and also the Northeast Atlantic. So those are geographically the marine areas in Europe. However, because of this zoning system of the UNCLOS, these sea areas differ in terms of how much they are covered by EU legislation, EU environmental legislation. So as I already said, the UNCLOS gives competence to coastal states and hence the EU to regulate marine environmental aspects in the internal waters, territorial waters, and the exclusive economic zone. So against this background, I have a picture of the Baltic Sea here. Sorry, it's a bit blurry, where we have the kind of like the lines drawn where the countries' territorial seas and exclusive economic zones are. So in the context of Baltic Sea, we can say that because the whole of sea area is covered by the exclusive economic zones of the coastal countries, it is only the Russians' areas that fall outside the scope of EU legislation. So basically, for example, the Marine Strategy Framework Directive is applied in all of the Baltic Sea, and the whole sea region basically falls under the protection requirements from EU legislation. However, the situation is very different already in the Mediterranean, that is on the one hand shared with EU member states, but then also third countries. So in the Mediterranean, for example, it's maybe a little bit more than half of the sea that is in the scope of application of EU legislation. And of course, this affects a lot of the possibilities of EU legislation to have such a reach to actually improve the state of the marine waters. In the Northeast Atlantic, it is even more limited, the scope of EU legislation. So it's only near the coast of the coastal member states there, but a lot of the ecosystem actually falls outside the scope of EU law. Just a final illustration of this interaction of these legal frameworks. So on the one hand, we have the UNCLOS that provides the most comprehensive regime on marine law or law of the sea. Then we have the regional seas conventions that fall within the scope of UNCLOS, but target especially the environmental protection aspects and other aspects in the regional context. And then lastly, we have EU marine environmental law that has to stay within the scope of UNCLOS, but also has to be there to implement the regional seas conventions. So both of these international law layers affect the content of EU legislation. About the structure of the EU legal framework, well, there's actually no one marine environmental directive or piece of marine environmental legislation. That's something that we also have to note already here in the beginning. And there's a very specific structure on EU environmental law in the field of water and marine environmental protection. So first of all, we do have some directives. Here you see the Marine Strategy Framework Directive that I'm going to speak a little bit more about next. And then we have the Water Framework Directive that aim to be quite integrated and holistic instruments that address the status of the waters and basically put forward some general policy planning frameworks that should encompass everything that happens in the waters, in the marine environment, and everything that addresses or affects those. However, because of this kind of like integrated or framework nature of these directives, they are not very specific in the rules that they give on different activities. So we still need a lot of sectoral, more detailed environmental legislation that addresses certain activities or certain impacts. For example, one important piece of legislation in the marine context is the Maritime Spatial Planning Directive that provides this spatial planning of member states adopting plans to plan the situating different activities in the seas. Especially in terms of nutrient pollution and chemical pollution, we have Industrial Emissions Directive, targeting industrial facilities. We have Nitrates Directive on agricultural nutrient pollution, Urban Wastewater Treatment Directive on the requirements on purification levels of urban wastewater treatment centers. So all of this legislation is relevant for also the Water Framework Directive and Marine Strategy Framework Directive. And there are multiple interactions between these umbrella instruments and then the more specific sectoral laws. But also, the last important category is that in the EU, we also have quite strong economic policy legislations that have a little bit different goals than environmental protection. So in the context of marine environmental protection, one is the common fisheries policy that harmonizes the aspects regarding fisheries. So when we talk about, for example, the adverse environmental impacts of fishing, we are operating within the scope of common fisheries policy that affects a lot also the reaching of the environmental objectives. On the agricultural side, we have the common agricultural policy that provides incentive subsidies, conditions for agricultural production. So when we think about the environmental protection and reaching goals in the environmental status of the seas and waters, we also have to see the interactions with these economic instruments and how well these play together with the environmental policy instruments. Yeah, that's just also an illustration of this. So basically we have the umbrella instruments, the Water Framework Directive and the Marine Strategy Framework Directive that encompass basically almost everything that happens in the waters and marine environment from the environmental protection side. But then depending a little bit what we look within there, so whether we're looking about pollution aspects, about biodiversity aspects, about climate policies, we have a range of sectoral legislation that then comes to play. And if we want to see, for example, how is the zero pollution of marine environmental regulated, we have to go to the sectoral legislation there and then see how it interacts with the more integrated instruments. And this is a very specific feature of water and marine environmental law, and also makes it a very complex field of environmental legislation, because you can never look at one directive alone, but there's a lot of effort needed in order to understand this system. All right, as promised, I will next focus a little bit more about our umbrella instrument on the marine environment, so the Marine Strategy Framework Directive. And the environmental protection angle of, or how the directive regulates environmental protection ambitions, in a way it's very simple. So there's only one very clear substantive obligation in the directive. So it sets an obligation to EU member states to achieve and maintain good environmental status in the marine environment, and it should be achieved by 2020. So it sounds simple that you have just one substantive requirement, but in fact, if you look at it, or if you start analyzing what this actually requires and assessed in the light of the variety of pressures that I described in the beginning, this actually requires a lot of different actions from the member states to reduce the harmful effects of different kinds of activities, to restore the environment, to come up with new legislation, policy instruments, other kinds of steering to ensure that the environment actually recovers to good status. The obligation here primarily targets each member state individually with respect to their marine waters. So, for example, Germany has to achieve good environmental status in their marine waters, Netherlands in theirs, Finland in theirs. So basically, there's this idea of member states crafting their own marine policies to ensure that their marine environment heals towards good status. However, because of the marine environment, it cannot actually be strictly divided into national marine waters. It's all one water column. It's all one ecosystem that interacts with one another. There's also a requirement in the directive, or at least an aspiration, that the member states would also work together, especially utilizing the regional sea conventions to ensure that good status is ultimately achieved in the entire sea region. However, as is often the case with environmental directives, there are exemptions that are available from this primary obligation of achieving good status. So there's a possibility for member states to postpone the achievement of good environmental status. And this is a possibility that has been quite actively used, because actually good status was not reached in any of the marine regions in the EU by 2020, probably not by any member states on any of its aspects either. There's also some other reasons that the member states can rely on to completely exempt from achieving good status at any point of time that, for example, relate to actions beyond their control, project of overriding public interest, etc. So quite wide exemptions available from that quite simple obligation. Well, what does good status then mean? So what are we talking about when we're talking about this substantive legal requirement? Well, good status is more specifically defined based on the so-called qualitative elements that are found in the annex of the directive. And just to simplify a bit, I have put them there on the side, and you can see that there are different characteristics, different pressures of the marine environment that come within the armpit of good status. So we aim for good status on biological diversity, good status on eutrophication levels, good status related to seafloor integrity, for example. And here, the Marine Strategy Framework Directive prescribes that it is the member states that have to define what good status means in respect to these different elements in the implementation process of the directive. So the directive only provides a rather general definition. So biological diversity is maintained, but what that actually means, what species are included, what habitats are included, what is the level, what is good. There is some implementation guidance, but it is ultimately the member states that have to do this definition for their marine waters. Also, there's a mechanism of environmental targets, which basically tries to be an intermediate step, like guiding the actions of member states, so that ultimately the marine environment would bounce back from the pressures and be in the status that reflects good status. And these are basically, they can, for example, be reduction targets for nutrients. So member states want to achieve, let's say, 20% reduction of phosphorus loading from agriculture by a certain deadline, or member states want to ban bottom trawling by 2027. So these are kind of like more operational targets that the member states use to structure their implementation efforts towards ultimately reaching the good status in the environment. What this actually means in practice, the member states' efforts towards good status, or the directive provides this process of marine strategy planning, or compilation of marine strategies. And it basically envisions that through these obligations for member states to compile these holistic and integrated plans, the member states would assess their current policies, the sufficiency of these, introduce new measures, also monitor the progress in the environment so that they can adapt their policies and measures if they see that it's not working. So basically, the idea of this process is that there's a 6-year iterative cycle that starts with just assessing what is the status of the marine environment, producing knowledge on, for example, the biodiversity, the nutrient levels, the eutrophication status. And then starting from there, the different steps of the process would kick in. So putting in place a little bit more operational targets, defining what good status is, then compiling programs of measures that I have highlighted there, because that's the important step. And then in the end, also monitoring process. So this is an extremely procedural framework on marine policies, because as I already mentioned before, there's little clear substantive regulation on different activities or rules regarding different pressures that are found in the directive. I have already touched upon this a bit, but I was talking about the program of measures, which is basically the most important instrument for trying to steer the marine environmental protection and ensuring good status is reached. So basically what this means is that member states have to compile this program that states what they will do in order to ensure that marine environment reaches good status. And measures here can be quite a variety of actions. So they can be different policies, for example, agricultural subsidy policies. They can be legislation, so restricting fishing practices, industrial emissions legislation, etc. Or they can also be more concrete projects like restoration efforts, like funding of scientific research, funding on large-scale restoration actions. As I already mentioned, the directive does not really harmonize what these should be. So there's only an indicative list of general types of measures that the member states can use. And that is basically already what is said here. So legislative measures, economic instruments, voluntary instruments. That's pretty much all what the directive says. Otherwise, there's ample flexibility of member states to decide what is that they actually want to do in the context of their marine policies. General features are that there should be some utilization of existing sectoral legislation, as I already mentioned in the beginning when I was talking about this structure of EU marine environmental law. But then there should also be this step of scrutinizing the legislation that they have in place, maybe amending something, adopting new national legislation, for example, to restrict fisheries, to establish more protection sites, to reduce agricultural nutrient loading. But yeah, there can also be other types of measures, such as voluntary schemes or information instruments that are utilized. But yeah, then the big but. It seems that as like against everything that I said before, I stressed the need in the beginning to have legislation that has the capacity to be flexible to respond in different types of pressures. And indeed, this kind of approach where member states design the policy instruments that they utilize based on what is the status of their environment seems rather flexible in this regard. So member states see what are the threats in their marine ecosystems, and then they design the policy responses based on that. However, the problem here is that the directive is quite specific on the procedural aspects. So the marine strategy planning process, like when do you have to do the assessment? Who do you have? What kind of public consultations have to be arranged? How to compile a monitoring program. So it is quite effective producing these plans on paper. So member states have adopted marine strategies that lay down the different phases of this process. However, at the same time, the substantive legal obligations of the member states are still rather, or actually completely unclear. So first of all, what is the legal status of this obligation to achieve good environmental status? Is it a legally binding as such? So member states are in breach if they didn't reach it. Is it just something that requires that member states try to achieve it? Or is it just a policy aspiration? So that's what we want to do, but yeah, let's see. We don't know actually still yet. Other question is what kind of rules govern the activities? So for example, if we would have a new project like an offshore wind park or something else that takes place in the sea area that requires member states to give it an environmental authorization, we still don't know whether the good environmental status objective has to be taken into account there, whether member states are, for example, required to refuse a permit if it would jeopardize reaching good status. This we still don't know. Also, what makes it more difficult to enforce or outline substantive legal obligation is the ample flexibility that the member states have. So because the directive does not require the member states to have any given systems on permitting or any given economic instruments or any given restrictions, but it is up for the member states to decide. It's also quite hard to enforce anything that the member states should do because they have the flexibility to decide themselves. Also, as already mentioned, the exemptions under the Marine Strategy Framework Directive are quite wide. So even though we don't necessarily even have the legal obligation, there are exemptions anyway, and they have been quite heavily relied upon by the member states. Okay, I noticed that I'm running a little bit out of time, so I'll just give one example here. So talking about the offshore energy deployment that I mentioned already in the beginning in the context of the Green Deal's aspirations. So the background here is that on top of the situation being that the marine environment is adversely affected by physical pressures already to begin with, there are very drastic growth aspirations currently laid down on renewable energy coming from the REPowerEU and Renewable Energy Directive that was revised last year. So there's, against this background, there's crucial importance in the need to try to ensure that this new development of renewable energy, especially offshore wind, does not further compromise the marine ecosystem, that it doesn't make the situation even worse than what it actually already is. This was something that was on my previous slide, but we do have the Habitats Directive, so EU Nature Conservation Instrument that also applies to some habitats in the seas. So then you have the Natura 2000 areas, protected areas, some requirements coming from there on permitting of, for example, these kinds of projects. However, those directives, so the nature directives, they were actually initially designed for terrestrial ecosystems, and that's why their coverage in the habitats of seafloor bottom is almost non-existing. So they also only cover habitats that are quite near the coast, but nothing, for example, in the territorial waters, or not much on the territorial waters or the exclusive economic zones. So against this background, it is the Marine Strategy Framework Directive that is the predominant protection instrument for the seafloor bottom habitats, for instance. Also, from offshore wind, we have other types of environmental impacts, such as impacts on birds, but also hydrographic conditions that can, for example, affect eutrophication or chemical contamination. So offshore wind development is definitely a relevant pressure on the marine environment. However, because of the ambiguities of legal framework, we don't really know how the environmental protection considerations are transmitted in this deployment now. So one option could be to utilize the maritime spatial planning framework that I was talking about. So utilize these spatial plans to direct offshore energy to areas that are least vulnerable, to try to ensure that there's coexistence of nature protection and then renewable energy. However, the Maritime Spatial Planning Directive itself, it doesn't really take environmental considerations strongly. So environmental protection is one of the interests that should be taken into account when member states adopt these plans, but by no means is environmental protection an ultimate aim or a heightened aim in these spatial plans. Also, because we still don't know about the legal nature of the good environmental status objective or its legal implications on decisions such as adoption of the spatial plan, we don't really get a lot of support from the MSFD on the spatial plan decisions. Yeah, and at the same time, we have quite strong instruments like the Renewable Energy Directive pushing for expedited, fast, streamlined permitting of renewable energy. So yeah, definitely a little bit problematic image in terms of conservation. Well, what about the next steps then? So where are we going next? As you've already heard from my presentation, the reoccurring obstacle on the effectiveness of the EU marine environmental law has been the ambiguity of the substantive legal rules, substantive legal obligations in the MSFD, and also lack of enforcement. Currently, there's actually a process going on in the Commission to revise the directive. That this is already mandated in the directive itself, and in practice, the Commission started a fitness check procedure on this directive already 4 years ago. So the aim of this process is to assess the directive to see whether it's fit for purpose, whether it's effective, whether it's suitable, and if it should be changed somehow. So as you remember, the deadline for achieving good environmental status, that was already in 2020. And after that, we have basically been in a little bit of a legal vacuum. So we don't know if there's a new deadline. We don't know what the substantive legal obligations are, etc. So there's a lot of pressure to change this aspect in the revision of the directive. So for example, come up with a new deadline and put it a little bit further down the future. Yet, I would say that the directive itself is already quite comprehensive, and it has the flexibility and it has the capacity to address a variety of issues together with other EU environmental legislation. And the more prominent problem has actually been the lack of enforcement. So today, we don't have any enforcement actions from the Commission that would target the substantive obligations. We have Commission overseeing that the plans are made on paper, but we have no infringement procedures, for example, on any substantive aspects. Also, for some reason, the questions related to the MSFD have not risen up in the national courts. So when national courts have, for example, assessed permitting of activities in the marine space, they haven't asked about the legal nature of the Marine Strategy Framework Directive. There have been no preliminary ruling requests from the European Court of Justice from the national courts. So this seems to be the more pressing problem than any of the formulations of the directive. And this is maybe something that maybe more fruitful would be to think about options for strategic litigation, strategic enforcement of the directive to see what it actually requires before we go into discussions of changing the deadline for its objectives. Also, I want to mention that we do have the nature restoration law in force since the summer. So we do have some new legislation. And you already heard from Anne Kickett's lecture a couple of months ago about the details of this regulation, so I will not go into those. The only thing I want to say is that the regulation sets forward legally binding objectives on restoring the quality of habitats that are currently there, but also re-establishing them in the areas where they have been lost. And these also concern marine habitats. So this would be of importance for the Marine Strategy Framework Directive as well, if these restoration obligations are implemented. So there's some promise with the nature restoration law. However, I would also say that there are some potential problems there as well. So first of all, the NRL is extremely complex. So it takes time even from very experienced environmental lawyers to understand the relationship of different provisions in this regulation, but also its relationship to existing laws like the MSFD. So that is not a straightforward question. Also, there's a variety of exemptions in the regulation that are prone to undermine the effectiveness. And also, if you can see the time frame for these restoration obligations in the nature restoration law, it is 2030 in the beginning, but up to 2050 before it's going to be implemented. So if you compare that to the 2020 deadline in the MSFD, you see that it's basically pushing the restoration, the biodiversity conservation efforts 30 years back almost. So in that way, is it really that nice of an advance? Well, that can be questioned in my opinion. Also, in the context of the nature restoration law, it also doesn't set any specific instruments or rules that the member states have to implement, but it also leaves a lot of flexibility on the member states to design the legal frameworks, the instruments, decide which way they want to advance the objectives. And we've already seen from the MSFD that this is problematic in terms of giving too much flexibility and rendering enforcement aspects of the law quite weak. So I'm a little bit worried that we will see the same problems in the context of the nature restoration law that we've already seen in the existing legislation. Yeah, to conclude, I have taken you through this quite complex legislative field. So we have the complexity of the marine environment. We have a lot of unknown factors. We have the international legal framework as well as EU sectoral legislation on different levels, which adds to the complexity of getting into the gist of what are the obligations, what does the law say. We know that there are a variety of different threats. It differs a lot between different regions. So that puts a heightened emphasis on the flexibility of the law. So flexibility is actually something that we do need in this context in order to have effective legal frameworks. We see that the MSFD has been quite good in operationalizing this flexibility. So there's room for member state solutions. There's adaptive policy cycle to do this iteration, to combine knowledge, to design instruments. But however, that has also meant that the effectiveness of the law has remained quite weak, and it remains extremely problematic going into the revision process of the directive as well. Yeah, thank you.